Order, order. Good morning and welcome. Sorry we were about a minute ahead of schedule. We'd like to try to keep on time. I have to ask colleagues to declare any relevant interests. And I'll start on that side of the table.
Yes, Sir Alan. I've been a criminal legal aid barrister for about 20 years prior to the election, receiving payments from the LSC. I'm not currently conducting any live cases, and I'm a recorder of the Crown Court.
I have been a member of the Law Society and the Family Law Bar Association and have received payments for publicly funded work. Since April of last year, I have reverted to a non-practicing status.
Thank you very much. Well, we're very glad to have you with us to help us with the work that we're doing on legal aid. And we have Laura Janes from Young Legal Aid Lawyers, Steve Hines from the Legal Action Group, Christina Blacklaws from the Law Society's Legal Affairs and Policy Board, and Paul Mendel, who was chairman of the Criminal Bar Association in the year that's just ended, I think. Thank you very much for coming. The government's argument is that legal aid has resulted in unnecessary litigation and the budget just has to be cut. What's your initial response to that?
Well, shall I start on behalf of the Law Society? We just don't accept that there is unnecessary litigation before the courts. And if there is any problem in relation to that, then we think that that can be addressed by a proper application of the merits tests which are currently available through the LSC to ensure that the wrong cases are taken out of scope rather than whole areas of law being taken out of scope. Litigation and access to the courts obviously should be the last resort. There's no doubt about that. And the Law Society is very much in favour of all types of alternative dispute resolution. However, it is absolutely vital that, particularly in areas of law where it is the individual against the state, that the government must not deprive citizens of access to effective remedies, particularly if that is going to be contrary to the rule of law. The legal aid budget is in fact tiny in proportion to the totality of government spend. That is not to say it should be ignored or it shouldn't be assessed. Of course it should. However, we believe there are many other ways to reduce legal aid spending which does not cut away at the basic rights of the most vulnerable and disempowered citizens in our society. And we'll come on to ways that we can do that later on.
It was put to us by a senior judge yesterday that there were a large number of judicial review cases which were, in the legal sense, without merit, and that a merits test applied within the judicial review process might significantly reduce costs. Do you have a view about that?
Yes. Yes, of course there should be merits tests applied to almost every type of law, and certainly to any law that's going to be publicly funded. I guess there are a couple of exceptions to that, and that's perhaps when the issue is of such great importance, for example, to parents and children when there is the risk that that child might be removed from their care. And we're delighted and relieved that the government is not intending to remove that from scope, because that is of such fundamental importance. But of course, as a broader point, there will be a huge increase in unmeritorious cases coming before all manner of court, not just judicial review, without proper and timely and helpful legal advice. What we're urging upon the government is to consider that front-loaded, relatively low-cost legal advice will actually save an awful lot of money downstream.
If anyone else wants to add, please, there are four of you there, so on any question, if you feel there's something you want to add, please indicate you do want to, but on the other hand, don't feel obliged to say something which has already been said.
Thank you, sir. Well, just to chip in then, the misleading picture that the government are painting is on a number of levels. First of all, the original intention of the legal aid system. Lord Rushcliffe's report that was the antecedent of the legal aid system. It was quite clear from what he said that he envisioned a system where people of small or moderate means could get help and advice in cases where a lawyer would usually be required. And that was the original intention of the system. It grew in terms of the coverage from the early 70s because of all-party recognition, particularly in social welfare law and other areas of civil law, that the population needed access to justice through being given legal aid. The government also tried to paint a picture of a budget out of control. And indeed, there was increases in expenditure in legal aid in its recent history. But if you look at the budget over the last 3 years, in fact over the last 5 years for criminal, there's actually no growth. And I've got the figures here, but when you look at the figures, and the government were successful, the previous government, in controlling expenditure, particularly on criminal, mainly through reintroduction of the means test in magistrates' courts, and now, as you know, that the means test is going through in Crown courts, and the reductions in criminal fees. There's a 12.5% reduction in Crown and High Court fees working through the system at the moment. Over the next 2 years, there's going to be further reductions. On the civil side, there was some growth in last year's budget, but that was mainly due to the fact of the Baby P case and public law children cases increasing. Quite a number of factors there, not just Baby P, but I don't think anybody in the political world or the legal world is saying that that's expenditure out of control. The other factor was the recession, and the previous government acknowledged this and put more money as a political decision into legal help, something that certainly Legal Action Group agreed with, because one of the effects of the recession is you do get a greater demand for civil legal advice across a range of the areas in scope at the moment. If you look at where the cuts are going to fall, and this is the final point I'd make on the misleading picture the government is painting, 164 million of the budgeted 350 million in cuts is actually on legal help. Now, legal help, as I'm sure you know, is the initial help that people get in the legal aid system. Legal help is very effective in heading off litigation because people can get early advice on their problem before it needs to go to litigation. So it's a wholly misleading picture to say that the government are introducing these cuts to try and prevent unnecessary litigation. The final point I'd make on that, there are areas that are litigated under legal aid, such as clinical negligence, that are within scope at the moment, and the government are proposing to take out of scope. This is a well-trod path. The previous government 10 years ago looked at clinical negligence and decided, no, we won't put it into CFAs. They listened to the lobby at that time, and it was decided that the cases that need a lot of investigation, expert reports, those sorts of cases in clinical negligence had to stay within scope. It's only around 20 million off the funding, but it's the one area perhaps that the government could have an argument to say that there is litigation paid for, but whether it's unnecessary, I wouldn't agree. I don't think those cases will transfer into whatever emerges after the civil funding reforms. There will be people who will be denied access to justice in those types of cases. I think I'll add to those comments later in the session.
James.
Yes, just very briefly, just to endorse what Mr. Hines says about not confusing access to justice with litigation. Of course, as law students, that's what we're learning to do, is to avoid litigation. I think if you restrict legal help or replace it just with telephone advice, there is, of course, going to be even more unnecessary litigation brought by litigants in person because they will have no other choice. On the judicial review point, I should add that I am a solicitor at the Howard League for Penal Reform, where I represent children in custody. We also have a public law contract, and sometimes, the importance of judicial review as a remedy of absolute last resort can't be underestimated. And I think that one of the concerns that we've seen from the public law project, done some excellent research on this, is that the number of sort of fairly hopeless cases that are going through for the permission test tend to be those actually either where the solicitor's not specialist in the area, and that's a quality issue, or where they're bringing it themselves. So again, another good case for that scenario being coming within the realm of public funding, where there is a strong merits test. And then just to endorse, I think, what Mr. Hines was saying about the sort of rather false economy of people not having access to justice at an early stage to resolve problems. Lots of the children I represent in prison have fallen through all the different hoops where they could have had legal help with not being excluded from school or getting help from social services, which has, of course, landed them often in very expensive situations in terms of being detained in custody.
George, anything at this point? Mr.
Yes, if I may, the concept of unnecessary litigation in crime, of course, is a slightly odd one, because people tend not to choose to be prosecuted. But we would argue that, in fact, the government's own actions are a driver in this increase in litigation. And I'd make these points. Firstly, Chris Hume's own research shows that between 1997 and 2009, the previous government created 4,289 new criminal offences. Now, not all of those, of course, would have fallen into legal aid, but a considerable body of them would have, and that causes an increase in litigation. The York study that the government refers to in its Green Paper in 2009 also points out, and it's a report that covers the period 2000 to 2006-7, it points out on Table 7.1 that there's a much higher number of legal aid cases per 100,000 of population in England and Wales than the next highest, which was Netherlands. And they trace that back to several factors. The crime rate is higher in England and Wales than in other countries, with the exception of Sweden. A higher proportion of cases in which there is a suspect are brought to court in England and Wales. And the proportion of suspects receiving legal aid was nearly twice as high as in France or in Netherlands. Now, that period exactly coincides with the abolition of means testing in 2000, which was not reintroduced until 2006-7 in the magistrates and 2010 in the Crown. And we would say that's a fact. So that's one point I made. The other point is this. The Crown Court Efficiency Group under Lord Justice Golding, of which I was a member, conducted a small survey of 2 Crown courts. What they found was that there was a practice of overcharging in the magistrates' court. And the CPS, and I'm not saying this critically, but the CPS were often reluctant to accept a plea until the case got up to the Crown Court. And again, the MOJ's own statistics show that about a third of cases collapse in the Crown Court because the prosecution offer no evidence or the case is slung by the judge. So you could argue that those cases were unnecessary litigation. And our point is that the driver, if there is, of unnecessary litigation in the Crown Court is very often the government's own actions.
Elizabeth Truss.
Thank you, Sir Alan. You talked about the overall cost of legal aid and the proposals by the government, and you mentioned how relatively high it is to other countries. Our understanding is that it's the highest per capita in the world. And you mentioned the comparison with some European countries. It's also expensive compared to some other common law systems, for example, Canada. And I just wondered, Mr. Mendel, if you could just explain where you see the differential lying. Is it the increased number of criminal charges in Britain? Is it the court process itself? Or is it social problems in Britain and the crime rate? How would you differentiate the drivers and say what is the key driver that's making legal aid so expensive?
All right. Can I just say my name is Mendel instead?
Sorry.
That's it. Well, firstly, we don't have the most expensive legal aid system in the world. The only comparison that we have that the government relied on, the MOJ Commission, was a report which compared 8 legal aid systems, including our own. And the only common law ones were New Zealand, Australia and Canada. And of course they're federal, 2 of them are federal systems, and the report itself found there's considerable variation across the federal systems. I've already pointed out what this report says are the drivers of the increase in legal aid. You cannot exclude the fact that for a period of 6 years there was no means testing at all, so everybody got legal aid, and that undoubtedly increased the legal aid bill. During that time, the spend on crime was very largely under control or fell. The Green Paper itself says that the spend in real terms fell by 11%. So more cases come into court, more people arrested, more cases given legal aid. Then you have to compare like with like. Now, for instance, in very many civil law countries, the costs of legal aid are low because a lot of the other costs, the court costs and the costs of prosecution, are dealt with in a separate budget. Again, if you look at the table, which appears, it's table 7.2. If you don't have the report in front of you, we can certainly send it in.
We have it.
I'm grateful. Well, table 7.2 on page 27 splits the legal aid spend per capita with the spend on courts per capita and the public prosecution costs per capita. When you add those three together, because those, after all, are the costs of prosecution, then this country is not the highest. In fact, Netherlands are the highest. And we come second, Sweden comes a close third, and there isn't a huge gulf. France is fourth, and we're talking about a variation from £50 per person up to £80 per person, and £90 for the Netherlands. So it's very, very difficult to make these comparisons, and the authors of the report themselves said that this report was not intended to be definitive, but was intended to provoke argument.
Yes.
So it's a tendentious report so far as the authors are concerned.
I think Mr. Hines.
Yes.
I think Mr. Hines caught my eye first. Say something about that.
Well, the Bolton-Perry research is very interesting, and the main point that it's making about the comparison across Europe is the difference between inquisitorial systems.
Yes.
And you look at the overall expenditure, and Ms. Mandel's correct, and they found that in Holland they actually spend more if you take all the costs of the system into account on criminal. It wasn't the case in civil. If you look at the figures for Germany, then in fact Germany spends more per head of population on its civil system than we do in the UK. And that's primarily for two factors. It's got a federal system that means that there's more costs in the court system, but also it's because it's an inquisitorial system, so there's more costs in terms of judicial time. The other point I'd make about the common law world, it's very difficult to come up with comparisons across the common law world. I'd give the one example of Ontario in Canada. Because it's a federal system, Ontario and their civil spend is more similar levels to the UK. Other states in Canada, it's a lot less. But certainly we would argue that you don't want a system where you have a sort of very minimum spend on civil because of all the knock-on effects to the rest of the system. And I think that the evidence this morning will bring that out.
I mean, I can see why the inquisitorial systems in Europe aren't a very good comparison because the cost exists elsewhere. But have the Canadian provinces looked at why it's much more expensive in one province than another?
Canada's an interesting country. Ontario is by far the most populous state, I think, in Canada. It's more of an urban state with large cities. And their legal aid system, particularly on the civil side, is very much analogous to our legal aid system. And so the spending is similar in level. It certainly isn't the same. It's around, I think, about half of what we spend in this country. But their system, they've gone, particularly on the civil side, for more salaried services and less procured in the private sector. That could be a factor. I suspect that it's mainly cultural differences and the way in which their court system works that's meant it's not the same costs in the system.
It's interesting you mentioned the court system. I'd be interested in Ms. Blacklaw's views as well on this. But given that we do need to reduce spending, and £2 billion is a large slug of money, and it's the kind of spending we do need to reduce across departments to make sure we can prioritise, on future economic growth, etc., etc. Very important. So, how would you propose making those savings in the Ministry of Justice if it's not through legal aid? We've heard previous witnesses talk about more root and branch reform of the system that's needed, and the fact that things like the court processes are actually driving the cost of legal aid. But what could the government do in the relatively short term to try and make those savings? Because in my view, I think in our report we need to propose where else the savings could be made if we are going to say things about the legal aid budget. So very interested in your ideas on that.
Okay, can I just, returning to your previous point, can I just make 2 points in regard to civil legal aid. The first is that the fact that we have perhaps the best civil legal aid system in the world is a mark of our civilization, something that I think we should be proud of rather than bemoan as a society. And secondly, that the need of this, particularly in civil, is largely created by poor decision making and actions of public bodies. So it's a responsive requirement rather than something that is a waste of taxpayers' money. In fact, and to come on to your second question of how can we make the cuts, the Law Society is not saying that legal aid should be immune from this. And in fact, we have some ideas as to how to bring about the £350 million saving without doing two things. One, reducing access to justice in this country, and two, reducing the supplier base so that effectively it has the same result. And I'm very happy to talk to you about those and to give you further information. The headline is that as far as we've so far done the costing, we think we can come up with about £470 million savings. So we're very keen to discuss these proposals with you. And part of that is along a polluter pays system. We think that there are real, almost win-win savings that can be made. If you look at the alcohol industry, and so much of our criminal litigation is due to alcohol abuse. If you put a 1% additional levy, and I'm sure those in the alcohol industry would not be keen on this idea, but nonetheless, if you put a levy of 1% upon that, that would give you probably about £85 million. Now that could come into
I think what we're particularly interested in is ideas within the Ministry of Justice and the justice system that could reduce costs, because there seem to be all kinds of bodies that we've discussed, such as the CPS and the Legal Services Commission, where previous witnesses, and I see Ms James wants to come, would you like to come in on that point, but where can we find savings rather than just putting up taxes? I'd be interested to see where they can actually be found in the system.
Yeah, just to draw your attention to the National Audit Office report on this, which did the comparative analysis and said, yes, £22 per capita, but it also noted that compared to other countries, we brought more than 1 million prosecutions in that time. So it's a really significant amount, actually, in terms of the amount of prosecutions that we are bringing in the country. That's not it's not just another factor. It's a really significant factor, and maybe it's that brings with itself a lot of additional costs. So there's a lot of cross-departmental savings from that.
Perhaps if I could just address a couple of specific points within the proposals that the Law Society accepts that will bring about significant savings. Experts' fees, which has always been a bone of contention, the spiralling fees. We have specific proposals around how to contain those expert fees. We believe that will bring about £11 million worth of savings. The supplementary legal aid scheme, about £10 million. Limited litigators graduated fee scheme adjustments, £23 million. So in total, there's just a few examples, but in total we believe that £68 million plus of savings can come appropriately from some of the proposals in the Green Paper. And then in addition to that, looking within the Ministry of Justice's budget for legal aid, the Law Society believes that if you had a much more robust enforcement of merits tests across the board, but particularly, for example, in family law, where I think there's been some real concern about inappropriate cases being fought through the courts, whether the child should be returned at 6 p.m. or 6:15 p.m, that sort of thing, you could actually stop those cases from coming anywhere near to the courts by having a proper merits test. We think that £12 million could be saved by that. And also another example is funding from seized assets of defendants. So again, within the system, those could be used, could be captured and used. So we have a number of very specific proposals that would be outside system, polluter pays, inside system, appropriate savings that could be made. We do need to look at whole system change, the Law Society think. This is an opportunity for us to review it. Nobody would end up where, or start where we've ended up in terms of how legal aid is procured, how it is funded, how it is delivered.
James.
Sorry, and just another saving within the criminal justice system itself. We spend around £300 million on child custody per annum. Now that's just something that hasn't, to my knowledge, been looked at. We have a very low age of criminal responsibility and the highest number of children in penal custody in Western Europe, 2,400 at any single time.
Could I just add, I echo what Christina said about the use of restrained funds. One understands the political argument, why not? But it's not at all uncommon in a fraud case for a defendant to be sitting on £1 or £2 million of restrained funds, to which he does have access for other items of expenditure, but not for his own defence, which seems, in our view, misguided. And that would certainly relieve the pressure on the legal aid fund. Insurance of officers, that is, insurance against their own fraud, so that they have private representation for fraud. It's a small body of potential defendants, and they could get that insurance. It's not especially expensive, and these are some of the most expensive cases in the system. So VHCC cases sucking up somewhere around £100 million per annum for a small number of cases. So those are two very specific areas within the system where you could relieve the pressure on legal aid.
Mr. Gummer.
Thank you, Sir. Just a quick supplementary to that, if it's possible to supplement such a comprehensive question from my colleague, Ms. Truss. Mr. Mendel, yesterday's announcement about ASBOs being moved effectively into kind of criminal law, Crimbos, I think they're called now. Do you, will that make a difference to this burgeoning body of criminal law which you've talked about, and I think you've got much sympathy in many parts of this committee about? Do you think that will create an even greater pressure on the criminal court?
Well, I think it's almost inevitably bound to.
So this is a trend that's going to continue?
Yes. I mean, I know this is not a very popular message to say to politicians, but it would be very useful, certainly as far as criminal law is concerned, if there were an extended period of benign neglect. Because it's
very popular among some of us.
I'm old enough to remember. I'm old enough to remember Harold Wilson. I won't tell you what I thought of him, but a lot of people used to say to Harold Wilson, "Don't just do something, stand there." We sometimes feel like saying the same thing to the government.
May I just? I think it's absolutely fantastic to hear such, I might say, very well thought out and creative ideas of saving money, because I think many of us are concerned about the restriction of legal aid, particularly to the people who need it most. But I suppose I have a frustration, which is the Legal Services Commission has been basically a bonfire of taxpayers' cash. There are £1 million pension pots all over the place. And there's just the sense that the whole system has been completely out of control. And my frustration is, why were these very good ideas not put forward 5 years ago or 10 years ago? I mean, it has taken a budget crisis to force out some of the creativity in the system. And I would urge you, please, to keep bringing forward these very good proposals. We are very receptive to well thought through and structured and well argued ideas as to how to save taxpayers money, and I wish we didn't have to do it in such a crisis situation, but if we could please work together on this rather than setting ourselves up as adversaries, I think that would be extremely helpful.
I absolutely endorse that, but I can say that, for instance, two of the ideas that I've mentioned, there are others, were put forward by the Bar last year. Yes, exactly, 6 months before the Green Paper came out, so we have been advancing these views before.
I think I must say on behalf of the Law Society, we had a full access to justice review, which has been running for 2 years, and lots of the creative ideas that we have come out of that, and we've been trying to fly these kites for a very long time, but now we have the opportunity to be heard, which is the silver lining, I hope, to this rather difficult situation.
Just a short question, Mr. Mendel, I think, probably was, sorry.
Black laws, it is.
Well, sorry, I should have a stronger pair. Has any work been done on actually sifting through some of the legislation which has been created in the last 10 years, and areas where we think we could cut away, the dross, so that we don't waste money on it. And I just go back to what Mr. Mendel said about Harold Wilson, the world-famous jurist Woody Allen said 80% of success is turning up. It's, no, on a serious point.
My clients don't say that.
No, but on a serious point, has any work been done on that?
Yes, the Criminal Bar Association, shortly after this government, the coalition came into power and announced it was going to have a reform bill, compiled a list of those statutes which we said ought to be reviewed and modified. It was overseen by James Richardson, who's the editor of Criminal Law Week. I can't tell you offhand what was in it, but it was a fairly comprehensive list. Professor David Ormrod, too, who's the editor of Criminal Law Review, compiled a very long list as well. And I know that was sent by the Criminal Bar Association to the Bar Council. I'm sure it's gone on from there to government. There is no doubt that the last 10 years has seen an explosion of technical law in crime, and some of that, one could argue, justifiably could be repealed. There's no doubt, for instance, Section 34 and Section 35 have introduced a great deal of technicality into the law. There is, I think, a strong argument Section 34 could be repealed, because with defence statements now, you do have to have your case before the jury. And really, this whole argument about what took place at the police station is a little academic. There are arguments that say we've gone too far with hearsay and bad character, and a lot of time in court is taken up with these. This is what delays trials. This is what extends them. There's a huge amount of technical law being argued in the criminal courts today that wasn't there 10 years ago.
Sorry. Yeah. Can I add to that? If you remove the hearsay and bad character provisions which the last government put in place, we think you could save £6 million. We've costed that. Law Society, again, has an extremely and growing list of statutes which should be appropriately repealed, and some proposals. So, for example, in our paper we say simplify housing law along the lines proposed by the Law Commission in their report Renting Homes. We think that would reduce the expenditure by about 20%. That's another £10 million saving. In family law, if you remove fault from divorce, you make it an administrative rather than a legal process. Now, I know there are lots of issues around that, but actually it is a difficult process for people to do by themselves because it is a legal one. If you make it administrative, then there's no need to fund that. People will be able to support themselves in accessing their own divorces. So there are there are political issues obviously in this as well, but there are savings, considerable savings that can be made by looking to reform the statute. So, and we would say that really this is the cart before the horse. Look at what you can do with reforming the statutes, then look at practice, then look at funding, scope and eligibility. Don't do it the other way round.
Mr. Governor. Thank you, Strand. Mr. Mendel, I was speaking to a judge at the weekend who's trying a murder trial at the moment, two defendants. One defendant has the benefit of a silk and a junior, the other one a senior junior and a junior. The Crown is being represented by a junior and a paralegal or solicitor of some description. And he said that this is now part of the course, and as a result, the public is not being represented as well as defendants are. Is that the same in your experience, and what is the effect of that if it is true?
Yes, it is, I think, a trend in my experience. It's common, I think, to see two things. Firstly, you're getting junior prosecutors being assisted by more junior prosecutors or sometimes High Court advocates, and the same is true on the defence side as well. Now, I don't want to enter into this old war between the two sides of the profession, but the fact is that an advocate who's been 20, 25 years in the profession and is skilled in advocacy is bound to have a better skill set than somebody who's not been doing it for as long. And that means that the quality of the justice that's being administered is not up as high as it should be. And there have been a number of factors that have caused this, and undoubtedly cutbacks in legal aid have been one of them. There have been cutbacks in CPS funding as well. I don't think there's an imbalance if that is suggested. I don't think that routinely the defence are better represented than the prosecution. That's certainly not my experience. What is happening is that there is a general lowering of the standard. I've got anecdotal evidence of cases being badly prosecuted because they've been briefed out at too low a level, and anecdotal evidence of cases being badly defended because they've not been adequately represented.
But were these complaints that you heard when you were fresh-faced at the bar from your elders, is this a perpetual complaint of any profession? I mean, I'm not trying to be
No, I absolutely understand that point. I mean, you tend not to hear that too much in the magistrates' court, which is where I spend quite a lot of time. I'm conscious of the fact that my perception changes as I get older, obviously. And, it's not a panoply being laid out in front of me with me, the static observer. But from the best that I can judge, these were not complaints that were being made. I mean, for instance, I'm at the Bailey a lot, and I can tell you when I first started the peering at the Bailey, you were only ever prosecuted by a TC. TCs at that stage weren't silks. They would always be assisted by a leading junior, a top quality junior, and you only had silks and juniors defending. Now that has changed. Over the years that has changed. And with that change comes some diminution in the quality of justice that's being administered.
Keir Starmer, when he was giving evidence a few weeks ago, was quite frank about the variability of quality across the courts and spending a lot of time seeing it and was honest about it. But he seemed to be struggling with how to address that. Do you have any suggestions?
You have to, this is going to be unpopular, you have to pay people a proper rate for the job so they will do it. In every walk of life, generally speaking, you get what you pay for. And if you pay more money, you get better quality.
Can I turn to you, Ms. Jones, just as a kind of to extend on that? Many people are concerned about the problems facing those entering the bar. Could you give your impression of the effect on quality and also on where the choices that young lawyers are making apropos whether to go in the criminal bar or commercial bar as a result of differential pay rates?
Yeah, absolutely. The young legal aid lawyers represents both solicitors and barristers, and a huge number of our members are students as well who are at that formative stage. And what they all share in common is a commitment to legal aid. Now, one of the we've done quite a lot of research to find out what motivates people to become legal aid lawyers, and it is almost entirely, I think 99%, do it out of a desire to participate in ensuring social justice. And one of the big problems with the current state of affairs, in fact, as they have been now for some years, is that young lawyers find it increasingly hard to qualify in either side of the profession. The bar is becoming virtually impossible, but training contracts are extremely hard to come by as well. The Legal Services Commission, one of the things that they did do that was very good was to have sponsored training contracts, about between 100 and 150 a year for some years. That scheme was axed last year, and it is almost impossible for new entrants to have any hope of qualifying. What they found is it's become absolutely essential to do a stint of unpaid work, which means that has a big impact on the diversity and the social mobility within the profession.
Have you been able to measure that specifically?
We haven't been able to measure it, but it's very clear that, I mean, the research says that typically about 50% of solicitors and barristers attended independent schools compared to 7% of the general population. I know that the Legal Services Board have done some research on gender and the ethnic minorities going through the profession, and it's still clear that perhaps the entry point, as you're about to come in, there is a level of parity between genders, but as you get to about 10 years qualification, it's virtually impossible. So there's a lot of work still to be done, and that's with the situation as it is, let alone the proposed changes. We've done a report on social mobility in legal aid last year in response to the government's diversity papers, which found that while lots of people were really keen to become legal aid lawyers, they just simply couldn't afford it. Over 35% of students who would like to do legal aid have got over £20,000 worth of debt. The starting salary for pupillage at the bar is about £10,000.
But what's the actual effect of that? Does that mean that the only people doing it are those with private incomes, or that people are living in penury, or both? I mean, what's the...
It generally, the impact seems to be, this is anecdotal rather than based on research, that either people are having to be supported by their parents and are not able to develop their own financial stability, so they're not able to buy their own homes or anything like that, for years and years and years. Or they're working all hours, God sends, and doing part-time jobs to complement. We've got some members that are working weekends in the supermarket and working all hours in the week as paralegals.
Just a few points to emphasise. The bulk of what the government are proposing, around 280 million, is coming from the scope cuts in civil. They're not looking particularly at Crown and High Court work. There's a few things to say in that. I emphasised in my opening statement that the previous government reduced fees and they're working through the system. There's something like, I'd say, 1,000 or so QCs and other barristers earning six figures from the legal aid system. And these people tend to be specialising in criminal and high-end civil work. Now, it's a market that's at work here. I don't buy into the argument that somebody's paid $20,000 a year and they do a bad job. I know of plenty of paralegals and even lawyers working that sort of money in the legal aid system. Similarly, you could have somebody on six figures that does a bad job. Quality goes beyond just what's paid for the job, but it has to be recognised that the high end of the bar, 1,000 or so, they're earning similar figures to consultant surgeons. It's what you place as the worth of those skills. There's about 14,000 barristers practising in the country. There's an argument to say that perhaps there's not enough work to go around, but you need to have that intake, I believe, to ensure that the cream or the fortunate rise to the top and do the Crown Court and other cases. You could, and as I say, it's not part of the government's proposals, but you could look again at very high-cost cases. You could look again at Crown Court costs and unifying the fees, which I know is one of the Law Society's suggestions. And you would take some money out of the system. But I don't think you would take anything near the order of 23%, which is what the government are wanting, and also you would risk quality. It's a balancing act you've got to play. And certainly it's not a balancing act the government are, in these proposals, addressing at the moment.
I think we need to move on, if we may. Of course.
May I turn to family law? The Green Paper, as you're probably aware, said that the provision of legal aid in private family law cases is creating unnecessary litigation, encouraging long, drawn-out and acrimonious cases. And it goes on to say that people should take responsibility for resolving such issues themselves. Do you think this is fair? And if you can, what proportion of the cases which reach the courts should or could have been resolved earlier?
Can I start with this? And just to explain, I run a large family and housing law legal aid practice in London. I'm the childcare representative on the Law Society Council. I'm the chief assessor of the children panel, so this is squarely my practice area. In relation, I think I've already made the point about that it does require emphasis, because we think considerable savings could be made, and also legal aid could be going to the people that the government and the public want it to go to. If legal aid merits tests are properly applied, they're there and are able to be applied. We think that they are fairly loosely applied at the moment, so cases are getting into public funding that perhaps shouldn't do. Now, in relation to, I'm sorry, can you, the first part of your question?
Yes, that the government believe that the provision of legal aid is creating unnecessary litigation and long drawn-out cases and acrimonious cases as well. Do you think that's actually the case?
If you have a look at the family legal aid at the moment in the private law sphere, over 80% of those cases, of those acts of assistance, as they're called by the government, don't actually go on to litigation. So you've got to think about why 80%, only 20% of cases that have been given legal aid go to the court. And that is because the vast majority of those clients are helped by solicitors to understand whether or not they've got a good case, to start to think in relation to children as to what is in their children's best interest, to focus on the future rather than what has happened in the past, and to be assisted to negotiate properly so that they need never go near a court but actually come out with outcomes that are really important for them as individuals, for their children, but also for society. So I would say that actually a lot of the work that is done, as Mr. Hines has said, at the low level is very supportive to ensure that there is no unnecessary litigation. But you will always have, as Lady Butler-Sloss said in the House of Lords recently, that hard core of cases where you have people who have got mental health problems, where you have people who have all sorts of drug and alcohol dependency, who have cognitive difficulties, who basically will not be able to be reasonable. And in family law, I'm afraid, to be reasonable, to come up with good solutions, it does take two to tango. You can be the most reasonable person in the world, but if your ex-spouse has got a mental health problem, then you're going to have to end up in court. It's most likely that you're going to end up in court. So there are cases which will always need to go to court, and those tend to be the most vulnerable people. So the people who don't have English as first language, the people who have these sorts of difficulties, who are the most deprived section of our community. And what we say is, do we really want those people unsupported at the early stages and ultimately unrepresented in court? That is not the mark of a civilised society. So, no, is the answer to that question. Can more cases be resolved through mediation and through support in alternative dispute resolution? Of course, we have collaborative family law as well as a different, another type of way of resolving cases in family. Yes, absolutely. And the Law Society is very supportive of as many cases as possible going through mediation. But we fear that actually, rather ironically, that less cases may actually get to mediation because solicitors refer to mediation. Now, how would individuals find mediation otherwise? It's a part of the process that of necessity to get legal aid. You have to go and see a mediator first and foremost. That mediator assesses whether your case is suitable for mediation. Now, if you don't go through that process, you may never find out about mediation or the benefits of it.
But of course, it is a truism that unless both parties sort of submit to mediation, it's not going to work, is it? And
yeah, and sometimes it fails.
Yeah,
you know. Even if parties are very willing to try mediation, sometimes it doesn't work. So we come back to that hard core of clients. And we have to think about this in context of the number of people who are separating and divorcing every year. It's 90% of them never go near a solicitor, let alone go to a court. It is really a tiny proportion of people who end up going to the family courts at the moment. But if you take away legal aid, that proportion is going to hugely increase because they're not going to have that stop, that checking mechanism, that good, helpful, supportive advice at the outset.
The government has said that they intend to retain legal aid in private law cases where physical violence is involved. Do you share the widespread concern about the Green Paper's reference to physical violence, as there is no clear definition of what that amounts to?
Absolutely. I think all representative bodies are very clear that the appropriate definition is probably that of the government, actually, and the ACPO, the Association of Chief Police Officers, and the Crown Prosecution Service. And I can tell you what that definition is, but it goes way beyond just physical violence. And in fact, there was a judgment of the Supreme Court 2 weeks ago, Yamshaw and Hounslow, which I think, well, us lawyers think drives the coach and horses through the proposed definition of domestic violence. But even taking away the sort of legalistic arguments, actually very vulnerable women and children, and sometimes men, will not be protected by this. What we know is that a lot of people don't seek protection because they're so frightened of the consequences of doing that. They don't seek protection. If they haven't had an order or a criminal prosecution, then they're not going to get help. And I can give you many examples of current cases where, and not to over-dramatise, but we would be very concerned that there could be serious injury and even death in relation to current clients who would not, had they not had this support from their lawyers and been able to access the courts, the consequences for them and their children would have been dramatic.
If you had a broader definition, would you create a perverse incentive which you as a lawyer might feel obliged to draw to the attention of your client? Say, well, if there has been any implied threat of domestic violence, it would be a good idea to make that clear because that would make you eligible for legal aid.
Of course, it would be our duty to assess, as it is at the moment, whether any client is eligible for legal aid, and we would have to be clear about the eligibility criteria. Possibly, you're right, that there may be a perverse incentive to either allege or pursue domestic violence claims, and that's why we go back to saying don't take the type of work out of scope, narrow it to what the government, what the public, what the professions feel is an appropriate limitation, so that those people who any of us, and we can give you hundreds of cases to say, actually all of us would say these people need help at this point in time. So we want to make sure that those people get the help rather than creating a sort of skewed system which allows certain people into all the whole treasure chest and others excluded and for no particularly good reason.
Yeah, I just on a supplementary on that. So what you're saying is the domestic violence test is just too arbitrary. There needs to be a more stringent merits test when it comes to private family law.
Yes.
Fundamentally. Okay.
Yes, because that would be fairer, more appropriate, and enable access to justice for these tiny minority, and remember it is a tiny minority who are eligible at the moment for legal aid, to ensure that they do have proper access to the courts, and they would be prevented from that. Now, I just don't want to emphasise that I'm not in any way undermining the import of domestic violence, and that must be a criteria.
Do you think the term domestic abuse is actually a better term than domestic violence?
Yes, absolutely, and that's the one that's generally used.
Yes. I just want to move the arguments on scope to the other areas, because of course it isn't just family law, though I accept that does seem to be the lion's share of the proposed savings that will be made. But we're talking about other areas as well, which we've touched upon, such as housing, debt, benefits and employment. I think this committee is well aware of the potential detriments that can occur with reduction in legal aid for provision of those services. But what I'm interested in is any proposals that you may have that could make savings in those areas, but in your view would be a more effective way of making savings rather than just a whole-scale removal from scope. And I'd be interested in the views of all the panel as to that approach.
We're proposing that the government initiate a commission to look at the funding and quality and provision of the other areas of civil law, particularly we're focused on civil and social welfare law. Our theory is that if the scope cuts go ahead, and give one example, it would reduce the number of contract holders in housing down to 226, and that's less than one per 3 parliamentary constituencies. We don't think there will be a viable national legal aid service if the scope cuts go ahead, and we think and we recognise that there are other funding streams and other providers of these areas of law, services in these areas of law. There needs to be a cross-government review of these services and look to create the best that we can from the existing providers and funding streams that we have. The other illustration I'd give, it's on page 4 of our submission. The legal aid scheme, particularly when you look at non-family cases, it's never really been a comprehensive national service. I'd give one example. There's the example of Surrey. The Legal Services Commission have a formula that's called indicative spend, and it means if legal aid was spread fairly across the country, there's an amount that would be spent in each area. Now in Surrey, it would be £2,264,806. In reality, and this is 3 years ago, £529,271 was spent, which is about 23% of the indicative spend. So that illustrates the fact that legal aid has never been evenly spread across the country. The other example I'd give here is Camden, Hackney, Tower Hamlets, all in London, all spending a lot more than what would be calculated as fair. Now, it's not to say that these areas are creating demand. What's happening is practitioners are responding to the demand in those areas, and the pattern of supply has been determined by that demand. But you don't have a service now which is fairly evenly spread and providing a service in every largish town. And
wealth isn't fairly evenly spread as between Surrey and Tower Hamlets.
Sorry?
Wealth isn't fairly evenly
No, it isn't,
spread
but
exactly what we want. I would far rather see legal aid, which is designed for the people who can least access justice and least afford it, being massively overspent in our most deprived areas and not spent at all in Surrey.
I'd agree, but
but that's the extraordinary interpretation, if I might say, Mr. Hines, of what legal aid is meant to be. We are not trying to provide a system of, everybody can access their pot of legal aid. It should be, and ought to be designed for the most disadvantaged. And if I might say, that is the sort of thinking that has got us into this mess. We're not focused on how to get it to the people that need it most.
No, the point that I'm making is that the indicative spend formula allows for the fact that legal aid is a means-tested benefit in effect, but we don't have the spread of services for the people that qualify for legal aid fairly spread across the country. It's an extreme example, Surrey, but yes, Surrey has pockets of deprivation, people that qualify for legal aid. I'd give another example, for example, Alnwick in the chairman's constituency. If you know Alnwick, you know that there's public housing there, that you know that there's need for legal aid, not on the same level I would readily concede as Camden, or perhaps in inner city Manchester, but there's need there. But it's not catered for, because legal aid has never been particularly good at catering for need outside of the larger urban conurbations, where there are pockets of need. And that's certainly, I appreciate the MP's argument, but I'm saying that legal aid should be a system, a safety net across the country that is equally going to serve somebody on benefits or qualifies for legal aid in Surrey as they would in Camden, inner city Manchester, or in fact Alnwick for that matter.
But isn't the problem with that we will end up with... I accept your point. I mean, the point you're making is legal aid deserts, I think, isn't it?
Yes.
Fundamentally, and I understand that, all right? But the problem is that resources are limited, and isn't it desirable to have, if you like, practitioners of expertise and excellence who may be serving a wide geographical area, but who may be based remotely from the town or village that the particular need arises from?
Yes, I can agree with that, and we can, I believe, with existing resources, put together a system, for example, where citizens' advice bureaus and other not-for-profit agencies link in with solicitors in private practice and the bar to provide a service. And I think that's exactly right. You could have a regional provider, for example, for public law family, that would work well, and they would be taking referrals from their local citizens' advice bureau, for example. The problem is that they're being hit on all sides. The one example I'd give, well, two examples. Financial Inclusion Fund is going. We're losing something like 1,000 people employed under that to give a debt advice. And the example only from 2 weeks ago, the Birmingham City Council are cutting back 600,000 on their citizens' advice bureaus. 5 bureaus will close. So that coverage, that you have that type of service where you can have the open door service that you can refer on where needs be to expert practitioners, is going. I believe strongly that the government needs to look at this whole problem in the round. It's not enough just to cut one part of the system in the Ministry of Justice. You know, you need to look at the entire system.
Sorry, I just wanted to get in on this.
Obviously, to support Mr. Hines and what he is saying about community-based services, it is really important that they are available, although, as you rightly say, they're not available across the country at the moment. So it's an opportunity for us to think much more creatively about how we can deliver the services. And the Law Society is not against internet delivery, greater telephone delivery, and may well be an answer to remote rural areas who do not have, I mean, Wales, for example, there's a handful already, a tiny handful of legal aid providers, so there isn't that access. So we need to look creatively at how else we can provide the service, but it isn't, those sort of remote service provision isn't the answer for everybody. And what we know about our legal aid demographic, these people, a lot of them will not be able to, for many and varied reasons, access services in anything but a face-to-face way. Those with mental health problems, I can recite the list again of the people who have the problems.
Probably anxious to come in on Wales.
You mentioned Wales now. One of the problems, it seems to me, is that the Legal Services Commission presume that if there's a large throughput of cases, then the expertise is there. That's simply not true. There is a mental health practice in North Wales which almost lost its contract because it was a few cases short. These are specialists who know nothing else. And by dint of the fact that they're situated in a semi-rural area, they haven't got the throughput. It seems to me there has to be some discretion involved here, otherwise we're going to lose good practitioners and thereby deny people good advice.
The point I'd make on the legal aid system, if you look at how it's spread throughout the country, it's highly dependent, those high street practitioners, on the 2,000 or so family law providers. What this will do is probably cut down around 60% of those providers. So you're going to be looking at a system of less than 900 providers. I don't think that will mean that you'll have, in many market towns and other population centres, a legal aid service. And unfortunately, the nature of the client base of legal aid is that they will travel to open door services within a 5-mile radius, but are not likely to travel long distances. It becomes a self-fulfilling prophecy, and housing law is another example. You look at under 200 or so providers in housing law. If there's no providers on somebody's doorstep, then the problem goes unsolved, and all the social problems that come with that. It costs something like £50,000 to rehouse a family in public costs.
That's not a new situation.
It's not a new situation.
You said earlier
yes.
how many parliamentary constituencies are involved. If I take the shelter contract in the northeast, that must cover 15 or more parliamentary constituencies and an area which is 70 miles long.
Yes,
so
it does.
Partly because of numbers, seeking more specialised advice in a particular area, in this case housing, has depended on going to somewhere more distant, but usually via the open door either of the CAB or the MP's surgery.
I think Ms James wanted to come in on the question I was asking about suggestions to save money in these areas other than taking it out of scope.
I mean, I'm afraid it is more of a general point about scope and about the importance of a holistic approach to people's needs. At the Howard League, we provide an access to justice service where people can just ring and say, this is my problem, this is my child's problem, and we do a sort of full legal diagnosis. And what's really striking is how many different areas of law and how many different specialists are required. Now, I recently represented a young person who was who had been sentenced as a child to a life sentence on his parole. And about 2 weeks before the hearing, the UK Borders Agency said that if he got parole, they'd deport him. It became absolutely essential then to make representations before the hearing to make sure that he would not be deported if he got parole, because it would completely undermine all the work that we'd put into the parole, and having legal aid for one would have meant that he would suddenly be deported to a country he'd never heard of, and actually you couldn't even have an effective hearing because you'd have to look at risk in the new country. That would now be out of scope, so it would totally undermine all the legal aid spent on the parole hearing. We were able to help him. We were able to make sure he had help, and that decision was made, and he was given a decision to be released, and that was an effective. That was an effective use of public funds, and it didn't undermine the work that we'd done. It would have been meaningless to him to go through the motions of having a parole hearing if all it meant was that he was going to be deported and had no access to justice to fight that. And so for the clients, it's actually about providing that kind of holistic service. And what we find with the access to justice service we have is that we spend days. We have a member of staff who spends practically all her time at the Howard League ringing up other solicitors and seeing if they can help. And it's a terrible waste of time and energy. And actually being able to provide holistic, good quality services would make much more economic sense.
So you're making a case really for sort of legal help at the threshold, which can cover a variety of issues, because the client doesn't come in saying, I'm a debt problem.
Absolutely.
I'm a whole range of different problems which need an answer. And that's a world away from then looking, representation obviously comes further down the line if necessary, but you're talking about the first stage.
And hopefully you wouldn't need representation in those kinds of cases. At our Commission of Inquiry that we held jointly with the Haldane Society last week, we heard from clients giving live testimony about legal aid, and there was a woman who'd had care proceedings, and yes, that would still be able to be funded under the current arrangements. But what she said that was really compelling was that actually it was the help she got with her divorce that was really important, because until she managed to make that separation with her husband, which she found a very difficult process to navigate, nothing was fixed in her life, and she wasn't able to take the children back and to look after them carefully, because it was actually the partner that was the problem. And so without that little bit of extra help with navigating through the divorce, the money on the care proceedings was virtually wasted because things didn't come together. And so those are the sorts of that kind of holistic approach. The Green Paper is very clear about not wanting to have lots of unnecessary bureaucracy and over legalism. Actually, trying to pare that away rather than saying we're only going to help this bit of you or that bit of you would make much more sense in our submission.
But in response specifically to Mr. Buffman's question, one of the suggestions that's floated in the Green Paper, and certainly one that LAG supports, though we qualify that support, is the client account interest. There's various estimates floating around of how much could be obtained from it, between 6 and 100 million. That's what we've heard. Certainly in the common law world, it's very common for client account interest to be used in this way. Certainly LAG would argue that the money should not go to the Treasury. There's potential, though, for creating a fund jointly administered that could pick up quite a large portion of the funding that's been lost from the areas of law. But it would meet with great hostility, I think, from the legal profession. And I think they would be particularly hostile if they thought that the money was just going to disappear into the coffers of the Treasury. But certainly, if the government were willing to look at this problem in the round, that's something they should be looking at seriously, I think.
There are two more topics I want to move on to.
Can I just deal with one final point? It may not be, certainly won't be relevant to crime, because as we know, matters under indictment are not judicially reviewable, but judicial review will remain in scope, and there seems to be a general exclusion of JR. Do you think that there's a danger, in particular in immigration cases, that there will be a flight to JR as a means of getting legal aid when other areas have been removed from scope?
Shall I just say, from a public law perspective, I think there are two dangers. I think there is that danger, and we've seen that already with the huge increase in litigants in person for immigration judicial reviews. I think there's also another issue, which is that the effective removal of legal help from a huge range of areas will mean that problems which actually could be solved by judicial review, which are judicially reviewable, go undetected. And that will be a detriment to justice, as it were, because if education cases are not in scope, but there is a gaping injustice in an education matter, it's never going to come anywhere near a lawyer who's able to say, hang on a minute, actually, you are entitled to this, and there is a remedy. Now, as a solicitor working with children in custody, I often have to threaten judicial review and rarely have to bring it. And so there is a great benefit in that remedy of last resort, which costs virtually nothing. It's done on legal help, frequently doing, threatening judicial review on legal help, at which point, once the authorities reminded of their duties, they are generally happy to back down.
I'll come back to you in a moment. I just want to make this point. The scenario I was looking at was that, in effect, lawyers would not be involved, for example, in an SEM tribunal. The tribunal would then take place, and then the lawyer would come in, get legal aid, and say, well, actually, the procedure was wrong, and we're challenging it.
That would be the only way to challenge it, so there is a risk of that. Yeah. There are the two risks of increased judicial reviews or things not being spotted.
Can I make 2 points in relation to that? First is that it's not just immigration, because immigration cases can end up in the High Court as well. And if we're going to look more broadly across the whole of civil and family legal aid, the number of cases that will end up in the High Court, in the Court of Appeal, as opposed to being resolved at the immigration, say at the Home Office decision stage or a tribunal, are going to be hugely increased. And it's this front-loading that we're trying to suggest to you, that actually £1 spent on early intervention legal aid will save, and the CAB have done work on this, on employment law, £8.80
yes, we've seen the
later
CAB
on.
figures.
We don't need to go into that, but it makes sort of logical sense as well, that actually if you can resolve things early, then you're going to save the public purse. And secondly, in relation to tribunals, obviously there isn't legal aid for representation in most tribunals at the moment, but there is legal aid for the early stages. So that means that bad cases are headed off, so they don't get into tribunals, and that appellants are aided and assisted to properly prepare their cases, which can be very complex, in terms of the documentation that is required, etc., so that their cases can be properly determined by the tribunal judges. And I don't think that we can count as a measure of success less cases going to court, because that is probably representative of unmet legal need and people not having their problems resolved, rather than actually resolving them if there's no early intervention. So I think there will be a much higher use of all levels of court, and an inappropriate use of their time. We talk to any judges about this, and they're extremely clear that they would be very worried that they're already limited resources, and we're talking about the same budget, of course, will be stretched to breaking point if there are more litigants in person before them.
On that very topic, just going to ask about.
Lead in.
Yes, actually, the question has been answered before I put it. But
I didn't mean to steal it.
Professor Richard Moorhead, in some research in 2005, said that if there is been an increase in litigants in person, that he's concerned that they sometimes damage their own interests, and they probably will create more work for their opponents and the courts themselves. And the question I would put is, how will this affect on the efficiency of court proceedings, the likelihood of reaching agreed settlements, and is there any danger to the fairness of those proceedings?
Of course, the increase in litigants in person, I think, will inevitably have a hugely negative impact on the efficiency and the fairness of the court process. And the research, which I think was misused in the Green Paper, the Moorhead research, but as you say, very clear that unrepresented litigants are more likely to make errors, and serious errors at that. They're more likely to file very flawed documents that don't assist the court. They are less likely to even attempt to settle their cases. All of these things will impede the good workings of the court system, and importantly for those individuals will mean that they don't have a proper hearing, a proper fair hearing. I was talking to some of the senior family judiciary who say that even if cases were dealt with more quickly, their experience is that it's because they have a litigant who sits there and doesn't say a word because they're so petrified by, no matter how they try to make the process inclusive and non-intimidating, just by being in a court, especially if there's a representative litigant on the other side. It is hugely intimidating, and just because it goes through quickly doesn't mean that actually justice is served in that sense.
Well, you say goes through quickly. I remember doing a case a couple of years ago, a family case which was listed for 3 days, and to my horror, the other side were not represented, and it took 7 to dispose of. So
that's my anecdotal experience. I represent a lot of children in private law proceedings, so when the court is so concerned that neither of the parents are able to act in the child's best interest, they appoint a lawyer to represent that child. And often I am the only lawyer in the court, and it takes a very long time. And that is because if people haven't had the advice at the early stages, they just don't understand what the issues are, what the relevant issues are. And that leads to a lot of frustration, and going back to domestic violence may actually lead to people taking the law into their own hands, and with, I'm afraid, quite concerning consequences.
Mr. Gummer, I've got a point on it.
If I might ask a follow-up question to that. Yesterday, Sir Anthony May was the first person to broadly agree with the Ministry of Justice's view that somehow the increase in time imposed by litigants in person would be offset by a decrease in cases being brought. But he is the only person so far to have agreed with the MOJ. And I wondered if I could just very briefly have your opinions about whether you thought the MOJ was right in its assessment or incorrect.
Can I give you some figures on from the impact assessment in the Green Paper, which is in my area as family law, that the impact assessment says that there's going to be 3,300 more publicly funded mediations, but there are 53,000 cases that family cases currently that go to the court. So if there's only 3,500 or thereabouts of those that are going to go through mediation, you've got a huge number of people who will be in the courts and litigating in person, or likely to be litigating in person.
Do you think that number will reduce by a similar amount to the increase in time caused by litigants in person?
No. Because litigants in person don't have advice that steers them away from court process, and good family lawyers, that is what they do. Court is actually the measure of absolute last resort. Nobody wants to see parents and children having to go through court process. So every other way of resolving cases is tried before that. And that, I think, is something that is really lost in this debate, is the benign effect of involving lawyers at an early stage, rather than thinking that each lawyer is trying to push their clients into litigation. The reverse is actually true. And my worry is that remove that layer of support and timely and appropriate advice, and you will have a flood of people who have no choice but to turn up at the court.
Okay.
Thank you. I'd like to press a little bit further on the sort of alternative provision of help and advice that I think we've touched on during the debate so far. But one of the arguments the government has made for restricting legal aid application is that there are other sources of help advice available, and perhaps there are some new creative ways to offer help and advice. And the analogy I like to use is, as an MP, you clearly get very complicated problems brought to you that require in-depth face-to-face analysis. But you also have lots and lots of things that come in that you can deal with in a telephone surgery or relatively quickly. Do you think that there is appropriate support, or there could be appropriate support provided from the existing universe, or potentially from some new models of provision?
Well, the main problem is that, I think as I've said before, other arms of government, Birmingham City Council being an example, are cutting back on the alternative providers. And you look at the Financial Inclusion Fund in particular, that will mean, as I said before, something like 1,000 debt counsellors across the country will no longer be providing a service. The other problem that I see is that there's an overconfidence in the pro bono community to take up the slack of the legal aid cuts. And certainly I sit on the London Legal Support Trust, which is a trust that has city firms sitting on it, raises money for a sponsored walk and other activities to distribute money to law centres and other not-for-profit organisations. Now, it's a small amount of money relatively that we raise, but it's successful. And many of the firms that we've got links with, they have pro bono rotas and undertake pro bono cases in law centres, particularly in London. What they tell me is that if you don't have the provision on the ground of law centres and citizens advice bureaus, then we don't have anybody to partner with for pro bono services.
We've taken evidence from them on that.
Oh, well,
Yes,
I won't reiterate what's probably already been said. As I said before, though, if the government wants to look at this in the round, then they should, and look at the other areas of funding, and look at the outside potential funding there is. I've given the example of the client account interest. But it's not something that's going to be done overnight. But it's certainly something that could be done within the spending review period. But my theory is that the Mojay are rushing to cut this money, around 50 million with the non-family legal aid, at a time when the rest of the alternative provision has been decimated.
Ms. James, you mentioned the Howard League's sort of advice to phone line advice provision. Would you be able to expand on this broader theme as to whether there are alternative sources that could perhaps deal with cases that perhaps don't need to be dealt with by qualifying solicitors receiving legal aid,
Yes.
or in different ways of doing it?
Yes, and at the Howard League, we will take all the information from the person that's calling and talk to them about what their problems are, and quite often, as you say, there will be certain things that can be dealt with easily by non-legal entities, and we will try and refer them on to those organisations. But what's also very interesting is that we often get people in quite desperate situations who have been working with very well-meaning other organisations, third sector organisations, for a very long time without great effect. And that's because that organisation just may not know that actually is a very simple legal solution to this. And if you were to know it and point that out to the local authority or the relevant body, things would become a lot easier. And I think it's actually about the appropriate use of resources, and I think we're actually in danger of trying to push so much away from lawyers that which will eventually ping back and even perhaps come back into court, and that actually it can become a diversion. So it's about the appropriate targeting. Certainly for young legal aid lawyers, it has become almost a given that you will be doing some sort of voluntary type advice work if you're going to be able to make your way, and that in turn, absolutely, the provision of additional pro bono help is a wonderful asset as an extra add-on, because we are, whatever we're looking at, we're not going to be getting more money. Any help we can get, that's great, but in terms of having services as of a right and to make sure that justice doesn't suffer, it can't be a replacement. So it's about really making the most appropriate use of resources.
Thank you. Just a couple of points. I think that CABs offer excellent generalist advice, but they would say they refer a lot of cases out to solicitors, and in fact we work hand in glove with a number of CABs and deliver the advice from the CAB centres themselves, because they don't do family work and they don't do the higher level of housing work. So there's a limit to what citizens' advice can do. Law centre federations do much more specialist work, but we were told yesterday at the Westminster Policy Forum that their funding will be cut from 21 million to 7 million because of this. Now, they're not going to be able to do what they are doing at the moment. So you're looking at across all of the sectors that deliver this sort of advice and assistance, a huge and devastating cut. The third point I want to make was about other ways of resolving problems, such as mediation. I'm a family mediator. I have been for 17 years, and I'm still very shiny-eyed about family mediation and what it can do for individuals and for their children. It's a marvellous resource, way of resolving problems for appropriate clients, but it isn't the right thing for everybody. So you do need other provisions around it. So to make that general point that yes, there are other services out there. They tend to be more on the cottage industry level, which means that they're serving a small and specific community. Those that are broader are having all of their funding attacked every which way. And if you don't have provision for solicitors, and it is not necessarily that solicitors are very well paid. If you look at the National Audit Office statistics, which I'm sure we've had quoted to you, legal aid solicitors get paid on average less than sewage workers. It's under £25,000 as the average legal aid solicitor's salary. So, we're not talking about this enormously expensive resource. And the Law Society doesn't think that people should make an enormous amount of money out of the public fund, actually. We're suggesting a cap of £250,000 for any individual to earn out of legal aid, because we can see that it's important that people are not making huge sums of money out of this. But believe me, legal aid solicitors aren't.
Does the Bar Council agree with that cap?
Well, can I make a slightly separate point, which I hope is related?
Wouldn't you like to answer Mr. Gummer's question before you make your separate point?
Well, the short answer is yes.
Oh.
Yes.
Thank you.
Can I make a slightly separate point, which is this: that so far as telephone advice is concerned, I think the last figure from the Legal Services Commission says somewhere around £175 million is spent on telephone and police station attendance advice. I'm not quite sure what the split is between the two.
Sorry, telephone and what was the police station?
Police station attendance advice. So attending at the police
the police station's phone to the duty.
attending at the police station and telephone.
Yes.
I'm working from memory. I think it's about 175 million. Policy Exchange, which is a think tank, published a report last year which suggested that of that, about 125 million was face-to-face advice. Now, there's an argument, what one could mount, to say, well, we could cut a lot of that. We could stop people going down to the police station in certain circumstances. It's not difficult to construct those circumstances in which you would cut back on police station attendance. You might say 40 or 50 million pounds that way.
I'm sorry, who is attending? Is this solicitors attending when there is somebody in the police station
Yes.
exercising their right to face this?
Yes.
Right.
Yes.
Yeah, I understand.
And as matters stand at the moment, generally speaking, the solicitor has discretion as to whether he or she goes down to the police station, depending on whether the defendant's going to be interviewed. But if the defendant's going to be interviewed, they have to be down. Now, you can construct circumstances in which you could cut the costs of that by limiting the circumstances in which the solicitor attended. But the MOJ's data shows that only about, it varies enormously around the country, but not every case where a solicitor attends results in a charge or results in a representation order, and it's sometimes a third or a half of those cases don't result in a charge. Now, is that because the solicitors attended? Is that because the solicitors attended, advised the defendant to answer questions? In answering questions, an explanation is being put forward, and that causes the police and CPS not to charge. I don't know the answer to that question.
Forgive me, Mr. Rendell, but I think the issue is about telephone advice is not the existing model, but to say, look, in a world where more and more of our transactions are conducted over the phone or indeed on the internet, is the rigid adherence to the face-to-face model for delivering what I'm calling low quality legal advice. I don't mean that in a derogatory sense, but I mean around some of these tricky areas of benefit advice, employment questions. Could you not envisage a model where that could be delivered in a far more cost-effective way by having legal aid practitioners essentially, using technology to offer advice to far more people at this sort of low level, if you like, of complaint?
Well, I'm looking at, obviously, from the criminal practitioner's point of view. A lot of defendants who are arrested do not have a lot of documents, so it's a much easier ask to give telephone advice. But what I'm saying to you is this. We don't know, because there's no proper research about this, the consequences of only giving telephone advice. It may be that the saving you make at the start of the system is lost, because at the end of the system you've got more cases coming into court.
Well, yes, but you can make that case about poor legal representation. I mean, that's impossible to prove, isn't it? Because we just don't have those sorts of benchmarks in the legal system.
Well, that's a very good point. It's a very good point.
But there are many telephone points. I mean, you had a very helpful table in the submissions about the number of telephone help, a bit like the Howard League one that we talked about, where this actually is provided. I mean, again, as we are facing this crippling budget deficit, can we not have some thinking about how to deliver this high quality advice in the lower cost method, perhaps even using the internet? What's to stop having web chats with legal aid lawyers, which essentially cost nothing?
I don't think any of the expert submissions are disagreeing with the concept of delivering legal services through telephone and internet. Certainly LAG's position has always been that these are useful services that can particularly act as a very good gateway and often provide diagnostic services. However, you've got to think of the clients, and certainly civil legal aid clients. We did a recent opinion poll a couple of months ago, and we found only 24% of people in DE social group were prepared to use telephone and internet advice. They are, as a group, very much excluded from telephone type services because of pay-as-you-go mobile phones and communication, other problems that mean that they tend to prefer, as a client group, face-to-face advice. And we would emphasise that you have to deliver a service that's effective and that people will use.
That's not insuperable problem.
No.
It's not, no. And certainly we would say that there is a potential here to look at a national telephone advice service. You perhaps could reconfigure what some advice do nationally to provide such a service, and I'm sure the government are looking at that. But it can't be the only option. Certainly our feedback from clients, and we're not representing lawyers, Legal Action Group, is that they want face-to-face services, certainly when it's complex problems, when there's language difficulties, when there's difficulties of comprehension, then you can't just rely on telephone advice to provide the service. You can have telephone doing the diagnostic work, referring appropriately, and making an appointment at a local level for a client.
I make a simple point about this. My previous life running a business, I knew every time I rang up my lawyer for advice that it costed far less to pick up the phone and speak to them. But of course it would be nice to have a kind of a nice long chat in front of them, and it might have been slightly more value added. But this people, when they're paying their own bill, make decisions about that every day. Why should that be any different for people where the taxpayer is paying the bill?
No, I don't have a problem with that, and certainly I think a service that was front-loaded with well-qualified and experienced people could provide that type of service, could provide that type of diagnostic service, quite appropriate, analogous to what somebody would do in business. However, you do have clients with specific needs, and to use the analogy of business, when the stakes are big and you can't just explain the matter over the phone, you go and see your lawyer, whether you can afford to or not. And certainly in business, that's what you do. And why shouldn't people that, as I say, at the lowest end of the social scale, have a similar sort of service? Yes, be able to access through telephone, and also, where appropriate, get face-to-face advice. And as I say, these are people will often have needs around the comprehension and language that means that sometimes telephone just doesn't work for them. And the classic example are the debt clients with a plastic bag full of letters from creditors, no idea what to do, under stress, probably depressed. They're not going to be able to go through that sort of information over the phone. You could have a client ringing up getting an appropriate referral and going in with a plastic bag of letters and putting it to the Citizen Advice Bureau advisor or whatever.
Don't worry, they come to us with that sort of pile of letters. We're running out of time.
Can I just make a couple of quick points about the actual proposal, which is that the telephone helpline is the only gateway into accessing civil legal aid services, because supporting everything that Mr Hines has said, the Law Society really does concede that actually telephone, internet delivery, all sorts of new media even delivery of legal services, one-to-many delivery is actually a very robust and appropriate way forward for a lot of information giving in terms of legal advice. So we're supportive of that, but we're not supportive of it being the only gateway into legal aid. For the reasons about the clients, which Mr Hines has set out, but also because of the reliance upon the current system being of such excellent outcomes. And we would say that there are excellent outcomes for those people who are contacting the current telephone provision because they are a self-selecting group with alternatives. There is no evidence or research in relation to whether there's any what I would call double dipping, people phoning up, getting a bit of advice and then going to see a solicitor. There may be that a lot of the cases that go through telephone helplines at the moment are actually that sort of toe in the water type. Well, I'm just going to phone up and get a bit of advice, and then when I want to actually access or do something about my legal issue, I'll go and see a lawyer. So we just treat the evidence about 90+% satisfaction with some caution, because it may be that those people, or if everybody had to go through it, that the satisfaction rates would bottom out.
I think, did you have a final comment? Right.
Thank you very much.
So, thank you very much indeed for giving us your time and advice and help this morning. We much appreciate it. Thank you.
Thank you.
Thank you.